Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing on page 8, it is recommended that the Commission adopt the proposed final rulemaking regarding 52 PA Code Chapter 56.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Kennard. Any discussion?
Yes, I have a statement on the matter.
Commissioner Place.
Thank you. Madam Secretary, I ask that my statement be placed into the record as if I read it in its entirety. Before the Commission today for consideration is a final rulemaking to amend the provisions of 52 PA Code Chapter 56 to comply with the amended provisions of 66 PA Consolidated Statutes Chapter 14. The changes to Chapter 56 encompass certain standards and billing practices to comply with Act 155 of 2014, as well as other changes to update the regulations. Of these changes, I would like to highlight one. In Chapter C, Subchapter C, Credit and Deposit Standards, Policies, Procedures for Applicants, we are amending the policy statement to further identify protected classes of citizens and customers in Pennsylvania. In Governor Tom Wolf's 2018 executive order establishing the Pennsylvania Commission on LGBTQ Affairs, he acknowledges the unique, diverse, and valuable contributions to the culture, society, and economy of Pennsylvania from LGBTQ Pennsylvanians. Governor Wolf further indicates that the Commonwealth is committed to providing equality and opportunity for all its citizens. The Commission could not agree more. As part of today's amendments to Chapter 56, we are expanding the anti-discrimination language to now include protections for color, religious creed, ancestry, union membership, gender, sexual orientation, gender identity or expression, AIDS or HIV status or disability. With these changes, we can all ensure that continued and equal access to utility services is preserved for all Pennsylvania's citizens. Thank you.
Thank you, Commissioner Place. Any further comments? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And continuing at the bottom of page 8, it is recommended that the Commission adopt in an omnibus motion the last item appearing on page 8 and continuing to include both items on page 9, ending with the cancellation of common carriers certificates.
Is there a motion to adopt the staff recommendations? Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 10, and matters presented by Chief A.L.J. Rainey in the Office of Administrative Law Judge. It is recommended that the Commission adopt the recommended decision of A.L.J.'s Salapa and Calvelli regarding the complaint of Joel Royer versus the Buffalo and Pittsburgh Railroad et al.
Is there a motion to adopt staff recommendation?
So moved. Second.
Motion by Vice Chairman Sweet, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing on page 10, it is recommended that the Commission adopt A.L.J. Watson's initial decision in the complaint of James Wolfgang versus the Pennsylvania Electric Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Sweet, second by Commissioner Kennard. Under discussion, I do have a motion, so I'm going to turn it over to Vice Chairman Sweet to preside.
Thank you. The chair is recognized for the purpose of offering her motion.
I ask that my comments be spread upon the record in their entirety, and I will summarize them for you. James Wolfgang filed a formal complaint against Pennsylvania Electric Company, or Penelec, stating that he objected to the installation of a smart meter at his residence because he believes it will contribute to ongoing health concerns for himself and his family. When Mr. Wolfgang did not respond to Penelec's discovery request, the ALJ ordered Mr. Wolfgang to respond or risk sanctions, but he did not. Penelec filed a motion to dismiss, and again, Mr. Wolfgang failed to respond. The complaint was dismissed with prejudice by initial decision issued on December 19, 2018, for the failure of the complainant to comply with interim orders entered March 23, 2018, June 29, 2018, and November 9, 2018, requiring the complainant to provide discovery responses and to identify witnesses. Normally, this fact situation would support the dismissal of a formal complaint, but in this instance, Mr. Wolfgang had asked for a secure method in which to transmit his family's medical records, and the record does not show that he received any guidance. I move that this case be remanded to the Office of Administrative Law Judge so that Mr. Wolfgang can be advised on his options for transmitting information and the types of protection that are available to him, such as a protective order and in-person transmittal of records. He can be educated regarding the procedure for filing confidential information as well, if any such information needs to be filed with the Commission. Mr. Wolfgang is cautioned that he is expected to respond to motions and orders in this matter, and that failure to do so again will result in dismissal of this complaint. Therefore, I move that, 1, the initial decision be reversed consistent with this motion, 2, that the complaint be remanded to the Office of Administrative Law Judge, and 3, that the Office of Special Assistants draft an opinion and order consistent with this motion.
Thank you. Is there a second to the motion?
Second.
It has been moved and seconded. Is there any further discussion?
Vice Chairman, I do have a statement on this case.
Commissioner Coleman is recognized.
Thank you. I'd ask that my statement be entered the record as though I read it in its entirety. As the chairman indicated, this is the initial decision in the case. This is a complaint from Robert Wolfgang, failure to comply with multiple interim orders, requiring him to provide discovery responses and witness identification information to Penelon. The motion proposes to remand this matter to the Office of the Administrative Law Judge so that Mr. Wolfgang can receive guidance concerning, sorry, I'm being distracted. Okay.
Can't hear you, sorry. Not working.
Equipment malfunction this morning. Coming into your space.
Commissioner Coleman, I pushed that button that shuts off your mic.
That's okay. Yeah, we'll work from this one. That's fine. Okay. I apologize for the disruption. The motion proposes to remand this matter to our Office of the Administrative Law Judge so that Mr. Wolfgang can receive guidance concerning how to submit confidential information. I don't support the proposed motion. Rather, I agree with the decision to dismiss the complaint. In my view, the presiding officer provided every opportunity for the complainant to comply with the discovery regulations and orders in this case. However, the complainant did not respond to the information request, and in doing so, chose a path of noncompliance here. Also, I don't believe that the confidentiality issue raised by Mr. Wolfgang justifies his repeated failure to provide the requested information despite being ordered to do so. I note that in his correspondence to the Commission, Mr. Wolfgang did not use his privacy concern as the reason for his noncompliance with the Commission's discovery regulations and order. Lastly, as part of the motion to remand, I have provided Mr. Wolfgang 20 days to inform the Commission whether he intends to pursue his complaint. I believe such an approach is entirely appropriate here, given the complaint's lack of engagement throughout the formal complaint process and the fact that he did not accept the initial decision dismissing his complaint. Thank you, Vice Chairman.
You are most welcome. Thank you. It has been moved by Chairman Brown, seconded by Commissioner Place. Any further discussion on the motion?
Just to note, I'll be voting with the ALJ on this for the reasons stated in Commissioner Coleman's statement.
Thank you. Therefore, we will vote on the motion. All those in favor say aye.
Aye.
Aye. Opposed? Opposed. The oppositions of Commissioner Coleman and Kennard are noted. On the motion as amended, is there approval to use the same vote? Without objection, the same vote will be recorded. Thank you very much, and I turn the gavel back over to the chair, who actually never gave me the gavel in the first place.
I did turn it over. I turned it well. You want the
You
gavel?
like to, no, you like to hold on to that weapon.
It was metaphorical.
Finally, on, I lost my place, page 10, it is recommended that the commission adopt ALJ Gould's initial decision in the complaint of Cynthia O'Dowall versus the Philadelphia Gas Works.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second? Motion by Commissioner Place, second by Commissioner Kennard. Under discussion. Any discussion?
Yes, Vice Chairman Sweet and I have a joint motion in this matter.
Commissioner Place.
Thank you. Madam Secretary, I ask that our motion be placed in the records if I read it in its entirety. For the Commission for consideration is the initial decision of Administrative Law Judge Marta Gould in the formal complaint filed by Cynthia O'Dowale against Philadelphia Gas Works. The ID grants Ms. O'Dowale a payment arrangement on her outstanding balance of $15,255.16. This balance consists of arrearages related to 2 separate service addresses, a significant portion of which we believe the complainant is not responsible. As Ms. O'Dowale has an active protection from abuse order complying with the Pennsylvania Protection from Abuse Act, the addresses referred to in this motion will be designated by letter, with A being the address where she lived from 2005 to July 2013, B where she lived from July 2013 to September 2015, and C being the address where she currently resides. Beginning in 2005, Ms. O'Dowale lived at address A and testified that gas service was turned on and off depending on when she had income to pay the bills. She testified that service had been terminated at address A on June 8, 2011. The account was in her name prior to termination, and Ms. O'Dowale testified, as supported by the testimony of PGW's witness, that no service was reestablished for that service address in Ms. O'Dowale's name or otherwise. As Ms. O'Dowale left address A in 2013 and established service in her name at address B, Ms. O'Dowale was later forced to leave address B due to a sale of the property, and with nowhere else to go, she and her children returned to address A to live with her estranged husband from September 2015 until December of 2016. She has an arrearage for that time period at address B of $2,856.78, an amount which is uncontested. In December 2016, citing no heat, etc., Ms. O'Dowale left address A and moved to address C. When she tried to establish service at this new address and request assistance from LIHEAP, she was told that she was not eligible due to meter tampering that had been discovered at address A in February of 2016. PGW billed her $12,398.38 for unauthorized usage at address A for the period of time covering from the June 8, 2011 termination date until the discovery of the tampering on February 25, 2016. Ms. O'Dowale testified, and PGW's own evidence shows that Ms. O'Dowale's address A account was terminated in June 2011, as noted, and that she had another account at address B from July 2013 until April 2015. There should be no question that following the July 2000 termination, she was not responsible for usage, authorized or unauthorized, at address A. Therefore, Ms. O'Dowale's balance should be properly credited the $12,398.38 misapplied for unauthorized usage, including the removal of associated late fees and penalties. We note that PGW is not without recourse regarding unauthorized use at address A, as there was at least one person living in that residence during the time in question. Consequently, the balance Ms. O'Dowale is responsible for is the arrearages that accumulated during her time at service address A prior to the 2011 termination, and for service address B, which at the time of the hearing totaled $2,856.78. Additionally, Ms. O'Dowale submitted as exhibits 3 separate money orders, though she testified there were more, where she made payments to PGW and the payments were not properly applied to her account or reflected on her statements. The amounts of $81.34 paid on February 11, 2017, $50 paid on March 11, 2017, and $252.33 paid on February 17, 2018, for a total of $383.67, should be deducted from the balance owed on her account. As this case is exempt from Chapter 14 due to the complainant's protection from abuse order, we should take guidance from Stifler versus Met Ed in considering a time frame to pay back this balance. Given Mr. Odewale's income and the magnitude of the balance, we believe that a 6-year payback period is affordable. We also strongly encourage PDW to discuss with Mr. Odewale all customer assistance programs which might be applicable. We also ask that PGW refer the complainant to its help program to inform her of any other assistance which might be available. Therefore, we move that 1, the initial decision of Administrative Law Judge Marta Gould in the above captioned case is reversed. 2, PGW remove the amount assessed for unauthorized usage at Address A, including any associated fees and penalties, from the account of Cynthia Odewale. 3, PGW credit Cynthia Odewale's account for the $383.67 in payments that were not properly applied to her account. 4, Ms. Odewale be granted a payment arrangement on her outstanding balance for a term of 6 years. 5, Ms. Odewale shall make monthly payments consisting of her current bill plus 1/72 of the balance accrued on her account, beginning with the first billing date following the entry of the final commission order in this case. 6, PGW provide gas service to Cynthia Odewale consistent with this motion. 7, the Office of Special Assistance prepare an opinion and order consistent with this motion. Thank you.
You have heard the joint motion of Vice Chairman Sweet and Commissioner Place. Is there a second?
Second.
I will second the motion.
allow you
That's
to
okay.
Or I'll withdraw my name from the motion to second.
I will second the motion for
Thank
you. Discussion on the motion.
Chairman, I do have a statement on this case.
Commissioner Coleman.
Thank you. I'd ask that my statement be entered in the record as I read it in its entirety. As you've heard in the motion, this is a fairly complex case with multiple service addresses, arrearages, and theft of service. Among other things, the joint motion proposes to find that the complainant was not responsible for the $12,000 of unauthorized usage charges at the service address. I don't agree with this outcome. There is clear evidence of meter tampering at the service address, and the record shows that the complainant lived there for much of the time of the tampering had occurred, and thus benefited from the theft of service. The administrative law judge did not find the complainant's testimony to be persuasive and that she had nothing to do with the theft of service, and I agree with that. And I agree with what amounts to be credibility determination of the presiding officer on this issue. Therefore, I don't believe that the complainant met her burden of proof and that she was improperly billed for the unauthorized service. By law, a public utility is entitled to receive payments for the service it provides. Otherwise, the unpaid bills, in this case, the $12,000 that we're talking about, are included as uncollectible expenses, which are all remaining customers must pay. Under the outcome of the joint motion, I am troubled that PGW's remaining customers potentially are on the hook for the $12,000 of the unpaid usage charges. Therefore, I do not support the joint motion this morning. Thank you.
Thank you, Commissioner Coleman. Any further discussion?
Madam Chair, if I could.
Vice Chairman Sweet.
Yeah, just very quickly, and I had scratched out some notes sort of in response to some of the things that I had read both in the motion and in the statement. I'll not belabor the matter with that except to say two things. One, at the time the complainant moved back into the residence, she was unaware and had no reason to be aware of the fact that the illegal tampering had occurred. And she no longer had an account with PGW at that time. For that reason alone, I think this ends up being a very difficult case in which to impose the entire burden of the meter tampering on a spouse who has been sort of in and out of residence with the husband and who is subject to a PFA order at this time. I would also note that PGW is not without recourse here. They have other legal tools at their disposal to attempt to collect this overage. And so it is not a case of we're closing the courtroom door on PGW. It's just that there are different forums and different legal mechanisms from which they can seek recovery. Thank you.
Right. Thank you, Vice Chairman Sweet. Any further discussion?
Just to note, Madam Chairman, that I intend to vote with the administrative law judge for the reasons set forth in Commissioner Coleman's statement.
Thank you very much. Any further discussion? So on the joint motion, all those in favor say aye.
Aye.
Any opposed?
Opposed?
The motion passes 3-2, noting the dissent of Commissioner Kennard, Commissioner Coleman. On the matter as amended, if there's no objection, we take the previous roll call. Seeing none, the matter as amended passes 3-2, noting the dissent of Commissioner Kennard and Coleman.
Madam Chairman, that concludes the regular agenda. Turning to the carry-in agenda. On page 1 of the carry-in, it is recommended by the Office of Special Assistance that the Commission adopt the proposed opinion and order regarding a petition for interlocutory review and answer to material question in the applications of TransSource, Pennsylvania.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Under discussion. Any discussion?
Madam Chair, I have a motion.
Vice Chairman Sweet.
Thank you, and I ask that my motion be placed upon the record as if I'd read it in its entirety. Before the Commission is a petition for interlocutory review and answer to a material question filed on February 1st, 2019 by TransSource Pennsylvania, LLC. TransSource filed a brief in support of its petition, and briefs in opposition were filed by the Office of Consumer Advocate, Citizens to Stop TransSource, York County, and Stop TransSource, Franklin County. Essentially what happened here is that TransSource filed its application based upon a perceived need to alleviate congestion restraints in Pennsylvania, Maryland, West Virginia, and Virginia, primarily relating to market efficiency with ancillary reliability benefits. The TransSource direct testimony is in support of this purpose, and the testimony of the opposing parties is also based on that particular claim. As this is a PJM-sanctioned project, the reports of PJM are relevant, and PJM reevaluates its pending projects through a continuing and ongoing process. TransSource attempted to include rebuttal testimony which updated the case regarding the stated reasons for this project, and for the first time included new PJM findings that this project would also address reliability violations and concerns. There followed objections from the three opposing parties, and eventually the ALJ struck the testimony regarding the violations. This petition for interlocutory review followed. In my opinion, the rulings made by the ALJs were not necessarily incorrect, but particularly in a transmission line siting case, it's important to have the best and most recent information, and that includes PJM updates regarding ongoing projects. If the litigation is allowed to proceed without this most recent relevant information regarding the project, then when the ALJ's ultimate determination came to us for review, it would most likely be returned so that the most recent information available could be considered. It is simply more efficient to include the information now while testimony and evidence is still being taken. Please note that the decision to answer the material questions presented to us today does not in any way prejudge the ultimate matter that is before the ALJs. Specifically, the TransSource claim that the other parties have already had ample opportunity to conduct discovery and to prepare their own cases regarding this subject is specifically rejected. In granting the request of TransSource, we must also ensure that the other parties will have an adequate opportunity to present and prepare their own evidence regarding the PJM report and to respond fully to the testimony of TransSource, which explains the PJM report. The ALJs will develop an appropriate schedule, which will provide all the time necessary to meet the demands of due process for all parties. Therefore, I move first that the petition for interlocutory review and the answer to material question petition filed on February 1, 2019 by Transource be answered as follows. A, whether the administrative law judges erred by striking Transource PA's rebuttal testimony regarding the project's reliability benefits, thereby violating 66 PA CS 332C, and denying Transource PA due process of law, answered in the affirmative. B, whether the ALJ's error unreasonably prevents the development of a full and complete record and denies the PUC access to the most recent available information determining the need for this transmission line project. That too is answered in the affirmative. Number two, that this matter be returned to the Office of Administrative Law Judge for additional proceedings consistent with this motion. And thirdly, that the Office of Special Assistance prepare an appropriate order consistent with this motion. Thank you.
You have heard the motion of Vice Chairman Sweet. Is there a second?
Second.
Second by Commissioner Place. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. The matter as amended, there's no objection. We'll take the previous roll call. Seeing none, the matter as amended passes 5-0.
Turning to page 2 of the carry-in, it is recommended by the Office of Special Assistance that the Commission adopt the proposed opinion and order granting the petition of the Pennsylvania American Water Company pending review of and consideration on the merits.
Is there a motion to adopt, is there a motion to accept staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Vice Chairman Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And finally, on page 3 of the carry-in, it is recommended by the Law Bureau that the Commission adopt the proposed order regarding the implementation of Section 1329 of the Public Utility Code.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion?
Madam Chairman, I just simply want to thank Sean Sparks, Sean Donnelly. They did a great job, and all the parties for their participation, Consumer Advocate and the companies, as we make 1329 work.
Thank you very much. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, that concludes all agenda items for consideration today.
Thank you very much. Before we adjourn, I would like to turn the microphone over to Commissioner Kennard for some statements.
Sean, you thought you'd get away unscathed, didn't you? John Kakan of my office is leaving the employee of the commission, indeed leaving the employee of the Commonwealth of Pennsylvania to join counsel's office at the Milton Hershey School. I want to thank you, Sean, for lending your legal skills, your insights, and your energy and good humor, very importantly, to the commission for the time you've been here. You helped my office and the commission find the right outcomes in many cases. And we'll miss you. Best of luck. And I'm sure that the Milton Hershey School will be an immediate beneficiary of their employment of you. So congratulations.
Let me add my congratulations to Sean as well. Before we close out, just want to note our thanks to our staff as well as the work of our utilities as we've dealt with a lot of high winds and outages this week. We appreciate both those joint efforts and continue to encourage both the utilities and our staff to work together to try to address those concerns. If there's nothing else to come before us, I will entertain a motion to adjourn. A second. And I assume everyone's in favor, but I'll say all those in favor. Okay, we are adjourned.